Hi guys. We've had several filings that I wasn't able to get to earlier, and even though you've probably heard these elsewhere, I did want to go over them just a little bit, especially because of the latest filing. Today we're going to talk about Marvel. Now, I had mentioned before that during this time of collecting discovery, that we probably wouldn't be privy to most of what's going on. Usually at this time, both sides are very busy. They're meeting the discovery demands that have been made of themselves and receiving the material that they've demanded, and using both to help make their case. What they collect builds on their own case, and what's asked of them gives them a peek into what the other side is asking for, and it helps them to sort out the defense. Now, as I told you before, we'll only get to hear about it when there's a problem, and there have been a couple of problems, with this being one. Surprisingly, we haven't had too many of these. Marvel has received a subpoena. They haven't been added to the lawsuit in any way. They were only subpoenaed to supply two things. These things were definitely not overbroad. They've attached a copy of the subpoena that they received and all of the information in it. And we see first that Wayfarer only asked for two things. The first one is all documents and communications, including but not limited to emails, text messages, memoranda, and meeting notes concerning the creation, development, modification, or portrayal of the character Nicepool from Deadpool and Wolverine. This would include things exchanged internally, among employees, or externally with writers, directors, actors, and other third parties. The second one is all documents and communications concerning Baldoni. But I wanted to bring your attention on what a subpoena is supposed to look like if you've never seen one before, because the topic of subpoenas was such a big deal in this case, because of the whole sham lawsuit. This is a proper subpoena. It's issued by the authority of the United States District Court for the Southern District of New York. We see the caption, Wayfarer Studios versus Blake Lively. We also see the case number. According to sources who've seen this mystery subpoena, the subpoena they've seen does not have a court stamp. This one has a stamp from the clerk of court and the attorney's signature. So keep this in mind in case that mystery subpoena ever actually does turn up somewhere. And if we get a chance to see it, we'll compare this to what information is missing. Now, something I want you to notice, and we're going to talk about it a little more in just a minute, we see the date of issue, and that was February 14th, 2025. If we go up a little bit, there's a box that says the date and time. This is the deadline for producing the information that's requested in this subpoena. That was March the 5th of 2025 at 9 a.m. Now, if you're going to fight a subpoena, in federal court you have 14 days, and that's what I want you to keep in mind, these dates and that limit. Because notice the date on this letter. This is well past the deadline, either to provide the documents or to object. And that's very surprising that it never gets mentioned, because this is well beyond that date. So first I thought, well, maybe they contacted them sooner and asked for it to be later. Maybe they were in regular communications and then this letter was filed. But surprisingly, that's not the case. And we see that in this letter. They begin by saying pursuant to, and then they give us a short list. This is a list of authorities, which is how people know the rules for each court that they practice in. This happens to be federal court, so it falls under the federal rules of civil procedure. These particular ones that he mentions are 26, which is a duty to disclose, and this is general provisions governing discovery. Basically, for this phase, this is where they're going to find everything that they need to comply with. In addition to 26, they also list 45, which is all about subpoenas. Next in the list, we have Rule 4C. This comes from what is called individual practices, and I showed you these several episodes back, more towards the beginning of all of this. Every judge has their own set of individual practices. It's like their own courthouse rules that go in addition to the federal or state rules. Next, we see a reference to the protective order, and this was something that was fought hard for. These are the things that won't be publicly distributed, or some things that will only be exchanged between counsel and not the clients. You probably remember the hearing where there was a big fight about this, and in the end, the attorney's eyes-only designation was granted. So that's what this list is all about. They're saying that they're complying with these specific rules. Now in this case, it's funny, because they list them here, but they don't really follow all of them. As you'll see, we already saw the dates didn't line up. But what are the issues and what are the actions that they're asking of the court? 1, they want to quash the subpoena. Now again, it's bizarre to me because nobody mentions how late this is. But 2, they want to issue a protective order prohibiting the disclosure of Marvel's confidential documents by any party or non-party. Alternatively, they ask that the court stay the return date of the subpoena and related documents requests until after the court decides the pending motion to dismiss of Ryan Reynolds. It just seems like such a funny ask because we're way past the return date. How do you stay it? But why did they want to do this? They said that it concerns the creation and development of one of the characters in their film. They also mentioned that the Wayfarer parties have served document requests for the same documents from Ryan, but they claim that these documents are proprietary and highly confidential, and their disclosure is likely to substantially harm Marvel. Furthermore, they say that these documents are irrelevant to the claims in the case, and that the disclosure would be improper and inconsistent with the federal rules. Now, it's interesting that they don't list which specific federal rules they're referring to, and it probably would have been better if they had done that. We're going to go through the next couple of paragraphs before we jump to the response by Wayfarer, but they mention the background of Deadpool, that it's a series of interconnected films, that it was released in July of 2024, and that it features a number of different versions of the Deadpool character. It lists some of them here like Ladypool, Dogpool, Kidpool, and Nicepool. They refer us back to the first amended complaint where the allegations are made that Blake and Ryan have continued to leave breadcrumbs in their campaign for mocking and bullying Justin, stating that Nicepool is a vicious caricature of Justin. They also say that the scenes that Nicepool was in were intended to be a transparent and mocking portrayal of Ryan's warped perception of Justin. Now we're going to jump over to the response from Team Justin. So an answer to my question was, did they let them know that there was going to be a problem with the deadline? We find out here that they didn't. They didn't contact them until April the 2nd, past the deadline. Now jumping back just for a second to the Marvel filing right at closing, they say, I certify that counsel for Marvel met and conferred with counsel for the Wayfarer parties in a good faith effort to resolve this dispute prior to filing this motion. Now why are they saying this? Because one of the authorities that they listed gives clear instructions about these situations. This is Judge Lyman's individual practices. It referred to 4C, and 4 is all about conferences. C is specifically discovery disputes. Now what does Judge Lyman say? If you have a discovery dispute and you want to raise it with the court, first you have to attempt to confer in good faith with the opposing party. You can do it in person, you can do it by telephone, but you have to do this first. Then, if it has not been resolved, you file this type of letter, and then it gives the instructions for the letter. It can't be any longer than 3 single-spaced pages, and it tells them what it's supposed to include, the time limits for filing it, which is 2 business days, and also that they must be prepared immediately to discuss it with the court. The judge is busy. It has to go according to his availability. So when they file this, they must be ready in case he calls them. Now, why do they mention this? Because here in the response, Team Justin says, contrary to its representation, Marvel did not meet and confer with us in a good faith effort to resolve this dispute. But on April 2nd, Marvel sent the Wayfarer parties a letter containing its objections to the subpoena. The same objections in this letter. On April 7th, my office met and conferred with Marvel's counsel via telephone. We attempted in good faith to address Marvel's purported concerns about confidentiality and relevancy, but here's what they say happened. Marvel's counsel interrupted us, refusing to engage in that discussion. Instead, Marvel's counsel interjected and stated he merely wanted to know what documents the Wayfarer parties really needed, regardless of the subpoena's demand for all documents concerning the creation, development, and modification or portrayal of Ryan Reynolds' Nicepool character and B. Justin Baldoni. So Wayfarer's response is that they wanted Marvel to search for and produce documents concerning Ryan's participation in the development of Nicepool and the communications related to Justin, including the character's portrayal of Justin. They say that Marvel's counsel agreed to discuss that limited subset of requested documents with Marvel, and then the telephone call ended. But lo and behold, the next communication they received was an email stating that Marvel would be moving to quash the subpoena, and then this letter that we're considering today. So even after a conversation where Team Justin agreed to a narrower scope, instead of following that, they just filed this. But this narrower scope is quite reasonable. If Marvel has problems with confidentiality and proprietary information, if you just look at Ryan's participation, in the development of Nicepool. That should limit it enough if the character was not connected to Justin. If the character had been part of the script, part of the creator's plan all along, Ryan's input should be very minimal. But if, as many of us presume, this character was put in by Ryan, that would be separate from Marvel's creative team and would not have all the risk that Marvel has stated. But instead of just following that narrow scope, they file this. So their first statement is that it should be denied because of its failure to meaningfully meet and confer prior to seeking judicial intervention, because that's required by Judge Lyman. Their second point is that Marvel neglected to advise the court that the Wayfarer parties proposed to narrow the scope. So when you go running to the judge and say, it didn't work out, but you don't admit your part in it not working out, that's not fully being honest. That's making it like it's the opposing counsel's problem. It's their fault. And Wayfarer wanted that cleared. They also say they inaccurately represented to the court what we're seeking. And they clarify again that it's the documents about a specific character and the documents concerning Justin. They're not asking for the whole creative process to the whole movie. And when it comes to Justin Baldoni, nowhere in all of the Marvel property, in all of the Marvel documents, and in all of the Marvel communication should there ever be the name Justin Baldoni. So if they're going to claim innocence, his name shouldn't be there anywhere. If it's there, it's not there for any good reason and should therefore be turned over as evidence. Then Marvel says that they understand that a notice was provided to Ryan about Nicepool-related documents. And then in the footnote, they make sure to add that because of Ryan's creative participation in Deadpool and Wolverine, that he had possession of Marvel's documents relating to the creation and development subject to contractual confidentiality obligations. So they're saying, we don't want to give you these, and you can't get them from Ryan because he had those documents subject to confidentiality. But here's the thing. Like I just said, there shouldn't be any mention of Justin. His name shouldn't have anything to do with the production or the creation of this movie. If his name's not in there, they have nothing to worry about. All they have to say is, it doesn't exist. It never happened. But if his name is in there, it's a problem. Marvel goes on to say that the party issuing the subpoena must demonstrate that the information sought is relevant and material to the allegations and claims at issue in the proceedings, after which the burden shifts to the movement to demonstrate undue burden imposed by the subpoena. And then they try to invoke the privilege. And they state that it's in the Federal Rules 45A. Now, as I said earlier, 45 is all about subpoenas. This document is just so lazy to me. They put it down as 45A. But 45A doesn't say what they quote it to say here. In fact, you have to go down to 45D3B, where in fact it discusses what they say. This is under quashing or modifying a subpoena, disclosing a trade secret or other confidential research development or commercial information. Get your codes right, Marvel. So they're not saying it doesn't exist. They're saying it falls under protective order because it's subject to contractual or other obligations of confidentiality. Then they go on and say that the claims for defamation and false light must be based on false statements of fact, not merely ideas or opinions. They say that in the first amended complaint that the Wayfarer parties allege that Nicepool is a caricature and mocking portrayal based on Ryan's perception of Justin. So they said because of this, the portrayal of Nicepool is not actionable as defamation, that it's clearly just a joke. That reminds me so much of Blake. After saying that Leighton Meester was born in a cage, she goes, oh, it's just a joke. So it's a joke, not grounded in any factual basis. But how do they say that when most of Nicepool's dialogue comes straight from what they're accusing Justin of saying and doing improperly? They go on, if the court finds that they're relevant, they should still prohibit it because it's unduly burdensome and that they seek highly proprietary and confidential documents, the disclosure of which would harm Marvel. That these are particularly sensitive because they relate to the development of a character in an ongoing movie franchise, and stress how important it is that the storylines are interconnected, the plots and characters including crossover events and sequels, that it could affect their upcoming unreleased projects, and that this information is closely guarded by Marvel, and that these concerns are even more heightened because the case is followed closely in media. And this is confidential information they don't want to disclose to the media. They repeat that it's not relevant to any claim, that it would cause potential harm to them, and they ask the court to quash them. Wayfarer says it's irrelevant, because according to Marvel, the character is an expression of opinion, and that this might be relevant to a motion for summary judgment, but it's not relevant at all to determine the propriety of the subpoena. And that even if it were found to be an expression of opinion, and therefore inactionable, still is clearly relevant because it comes to the question of Ryan's alleged malice. Ryan's insistence on this ill-fitting and belated addition of Nicepool to the scripts during the period at issue during this litigation is in fact credited in the film It Ends With Us. And I've shown you that a couple of times. And so this information could establish malice not only in connection with the portrayal of this, but with other defamatory statements that Ryan made about the same time. And that those statements did cause Wayfarer parties substantial harm. And that this argument does not apply to the request for information concerning Justin. So, if the court finds that it's overbroad to get this information about Nicepool itself, if the court says, hey, this is proprietary, this is contractual, it's privileged because of those reasons, it still doesn't apply to any mention of Justin. Justin's name should just not be there at all. If it is there, it should be handed over. Let's talk about something called the bright line rule. This is an objective rule, and it resolves legal questions in a straightforward and predictable manner. Not every issue in every case can be resolved using this method. And so there's another method, and it's called the totality of circumstances. This is a type of analysis or a test where the court considers balancing circumstances and contributing factors of the situation instead of just this strict, bright line. It's much more flexible, and it makes much more sense in this situation because this situation has so many different moving parts to it. There are multiple accusations about Ryan. They're trying to establish defamation. They're trying to establish malice. They're trying to establish conspiracy and collusion. So a bright line standard is just impossible in this situation. So the court has to do this analysis, take in the totality of circumstances to help determine whether or not the subpoena is valid. So involved and part of this test would be the context in which a statement was made. For example, was a whole character added this late in the game specifically to mock Justin? And then we have, like it just mentioned, why on earth would this character Gordon Reynolds, who's named as the person playing Nicepool in the end credits of Deadpool, Gordon Reynolds, why would this be listed by Blake in the end credits to It Ends With Us, where she's thanking people? It has no business being in that movie. And it wasn't put there by anyone from Wayfarer or anyone from Sony. This was specifically put in there by Blake in the list of people she wanted to thank. Right there with her children, other family members, and friends. Right there with her name dropping of Bradley Cooper and Britney Spears, people who had nothing to do with the movie. Makes me wonder if that was her yet again telling on herself that they helped with some of this conniving. And the reason all of her friends are sweating it out right now, seeing if they're going to be served with a subpoena. They seem to think that they're so cute and clever, but all of these brags, they make it so easy because they tell on themselves. Just like this, bringing Gordon Reynolds' name into here so boldly and brazenly, just telling on themselves that this specifically applies to Justin. Then we have this Instagram post that Blake made, where she bragged about all the ways that she had influenced the movie Deadpool. She specifically referenced men posing as feminists. What else does she mention? Your feelings post-baby. This topic was found prevalently in the text between her and Justin. She wanted to wait and film the sex scenes later when she had some more time to lose the baby weight. Her feeling like she'd been fat-shamed. She also says, nice men who use feminism as a tool. And we know that line where Nicepool makes a remark about Lady Pool's body not looking like she just had a baby. And when he's told you're not supposed to say that, he says, it's okay, I identify as a feminist. So besides of those important points, I just wanted you to take a look at the very last line. She says, I've never been more proud, and I've given birth 4 times. So she is more proud of the way she influenced this vile, gory movie than having given birth to her 4 children. I'm sorry, these people are sick, in my opinion. This stuff is forever. These kids are going to grow up and see that. I mean, it's obviously more important. We know what they made Inez say that she didn't want to say for the sake of this movie. So I believe her that that's the way she feels, but I'm also disgusted by her for feeling that way and for saying it. Anyway, back to the documents. Now, in talking about this totality of circumstances, it goes on to say that under New York law, that this is what the courts generally consider. 1. Whether the specific language in issue has a precise meaning which is readily understood. I mean, Blake and Ryan didn't just breadcrumb this. They left huge signs for this. They left landmarks. 2. Whether the statements are capable of being proven true, such as Gordon Reynolds, who's mentioned in both movies as the actor playing Nicepool, and then his name ended up on It Ends With Us being specifically thanked by Blake. All of the things they had him say. I haven't heard of anyone on either side of this mess that doesn't think that this is Justin. And 3, whether the full context of the communication in which the statement appears is such as to signal readers or listeners that what is being read or heard is likely to be opinion, not fact, and that the pertinent facts are most appropriately developed by discovery and presented either by way of a summary judgment or at trial. Now, we've talked about summary judgment before, but it was quite a while ago, and there's a lot of new people here. So just as a review, this is a motion that can be filed before the trial begins. It's another motion, just like motions to dismiss, that's often used and rarely granted. It would be granted in a case where the evidence is so overwhelming that the judge would rule that a jury's verdict is absolutely certain one way or the other, so that the party whose favor the judge feels would 100% win can be granted this summary judgment, which means no trial, no jury, the judge is making the decision right then and there. It serves the same purpose that a verdict would, meaning that that side actually wins the case. It also means that the other side can appeal, just like a jury trial. So that's what it's talking about here. And that's what Mr. Freedman says here. He says, well, their argument to defend this would be relevant for a summary judgment, but it has nothing to do with the propriety of the subpoena. And so he goes on to say that Marvel says that Nicepool is clearly a joke. The case that Marvel cites for this unsupported proposition that Nicepool is clearly a joke, and this is one thing that I've noticed about Mr. Freedman's documents, and it's something I really love, because the best filings, the best documents, back up what they say with cited cases. I always feel cheated when I get a court filing that doesn't have very many cited cases, because to me, it symbolizes one of two things. Either laziness, you don't want to look up the cases to support your legal argument, or your legal argument just isn't sound, and so you can't find cases to support it. But I love to look up the cited cases in these documents. And I love that he always looks them up too, because he always has a comment about them. I don't know if you guys have noticed this yet, but in so many of his replies, he says, well, the case you cited doesn't prove your point. In fact, it's the opposite. I've read that from his responses so many times. And here it is again. He says that the case that Marvel did cite for the unsupported proposition of Nicepool being clearly a joke is not grounded in any factual basis. That the case that they cite was decided after limited discovery on the issues was pertaining to a motion for summary judgment. And he's saying that's not even the case here. We're trying to get discovery. That case had some discovery and then went to summary judgment. It's not the same thing. So your cited case doesn't fit. And I have to say, I absolutely love that about him because it really shows them up. Going on, he says that Marvel doesn't explain how the subpoena is unduly burdensome. And this is true. This Marvel document is really bad about not supporting their legal arguments. You can't just state, well, the law says this. You state that, and then you back it up with these citations, and they should be the proper citations. So far, they listed the wrong civil code. They listed a citation that doesn't match this case. Like I said, it makes me think they're either lazy or they can't find anything to support their legal argument. So, stating it's unduly burdensome, but not saying why it's unduly burdensome is just really lacking, especially because the Wayfarer parties agreed to narrow the scope, to show their full cooperation. And there really shouldn't be a problem with this narrower scope. Wayfarer said, just for the stuff that has Justin's name. That name shouldn't be there. It should be a very narrow scope. If the name's not there, you've got nothing to worry about. How is it unduly burdensome? You're saying it's not there. If it's not there, you just have to say it's not there. And then add to it how much beyond the deadline we actually are. What were they doing all this time? They should have already had that information. And then if they comply with this, that should be it for them. They may not need to be involved anymore after that. And then they point out the contradiction. At the bottom of page 2, it says the Wayfarer parties certainly have other less burdensome means through which they can obtain relevant information, if any exists, from the parties. in the action, such as a request for admission or a party deposition. Okay, so now they're saying, go get it from the parties. Who are the parties? Ryan and Blake are the only two parties that could be tied to Marvel. But we already saw in the footnote they said that Ryan's under contract, and so you can't get anything from Ryan. So the suggestion by Marvel is that the Wayfarer party should obtain documents concerning Nicepool from the parties, including Ryan, and that's insincere because Marvel also seeks a protective order prohibiting the disclosure of Marvel's confidential documents by any party or non-party in this action. So they're simultaneously contending that Wayfarer should seek Nicepool documents from the parties, and two, the court shouldn't permit any party or non-party to disclose Marvel's documents. It's ridiculous. It's like someone wrote one part of this document and someone else wrote the other, and they didn't know what each other was saying. I honestly would expect Marvel to have better attorneys than this. This is sloppy. There are so many problems with this document. Then they get back to how these are particularly sensitive documents, because it's the development of a character in an ongoing movie franchise. Wayfarer says, but you know that the court has entered a protective order, and that this protective order provides for ample protection of any proprietary information. We all know this. This was such a big deal in this case, getting that attorney's eyes only provision. That means this information couldn't be leaked to anyone and would only be provided to the attorneys. Further, the idea that it's proprietary information about storylines, plots, and characters that's closely guarded is silly because this is only documents concerning Nicepool. The movie that Nicepool was in has already been released. That character is not in development. Not only that, the character was killed off, so he won't appear again. There's no harm that can come to Marvel for their secrets being revealed. And again, they messed up in the case they cited. This time, it's about scripts for unreleased films. And it was specifically about them being stolen by a former employee who had stolen company documents for personal gain. Nothing about this exists in this case. So the few legal citations they have are so disconnected from this case. Now they get to the alternative that Marvel asked for, saying that if the court doesn't grant this squashing of a subpoena, can they stay discovery until Ryan's motion to dismiss has been ruled on? And Wayfarer says Ryan didn't even ask for a stay of discovery. How are you going to ask for this? And then they add that there's no substantial grounds for dismissal in Ryan's claim, which makes it very unlikely that he would get dismissed. And even if he does, and it's dismissed with prejudice. Now remember, there's two ways to dismiss. You can dismiss without prejudice, which means that it can be cured by an amended complaint and stay in the lawsuit. And with prejudice means it's pretty much done. The only thing you can do is appeal. And that's not likely because courts do usually grant leaves for amendments. But they say even if that unlikely event happens, that the information would just pass onto the suit against Blake. Because Ryan is declared as an active agent of Blake working on her behalf. In other words, this whole Nicepool was done as retaliation by Ryan on Blake's behalf. So it will still be connected to Blake's part of the lawsuit. They remind the court again that the Wayfarer parties have proposed in good faith to avoid any undue burden upon Marvel to narrow the subpoena, and that they're okay with accepting anything that Ryan himself participated in the development of Nicepool. It's a very narrow scope, that and anything to do with Justin. They repeat that this film's already been released, the character's not in development, and any non-public documents can be marked confidential, which would keep them protected. So they respectfully request the court deny this motion to quash and compel Marvel to comply with this subpoena. We talked about compel last week. This is the court pretty much demanding that you respond and provide the information. If you don't, you can be held in contempt of court, which would come with some sort of discipline. Now, it just got more interesting, as I mentioned, with the latest filing. Marvel has now retained an attorney. This attorney is Adam Levin. He practices in California, and he specializes in employment law. Part of employment law is things like trade secrets, unfair competition, and invasions of privacy that are related to models, celebrities, and performing artists. And while we're on the subject of employment lawyers from California, in my last live, I talked about a certain person on Reddit that was trying to cast doubt on both creators and other attorneys. One of those attorneys that was being discredited was Ron Zambrano. She even went as far as to say that he was lying about being involved in the recent case where he sued a rapper. She referred to him as a dog bite attorney. Now, on the website, West Coast Trial Lawyers, they do represent clients with dog bites, but that's not all they do. He is also not just an employment attorney, but he's the employment litigation chair. He's been fighting for employees' rights for over a decade. And since 2008, he's exclusively dealt with workplace discrimination, harassment, wrongful termination, whistleblower retaliation, and wage and hour violations. He's settled millions of dollars in claims on behalf of aggrieved employees from various walks of life and backgrounds. Before he joined West Coast Trial Lawyers, he handled high-profile cases in Los Angeles, at Carlin and Bushbaum, things like the Long Beach Police Department, the Department of Water and Power, major corporations including Boeing, Ralph's, CarMax, Wells Fargo, Walmart, Macy's, and others. I don't see anything in here about dog bites. But just looking at this, he is the perfect guy to talk about this specific case. This is his field, harassment, workplace disputes. So if any of you have any question about whether or not he's qualified to speak on this case, worry no more, because he is indeed very qualified. But Marvel has hired this new attorney, and it seems to me that it's a big piece of news, because if it was a simple fact that there's nothing to implicate Marvel or Ryan about the creation of Nicepool, if there's no mention of Justin Baldoni anywhere in Marvel, that's all you have to say. We have nothing to produce, because it didn't happen. But the fact that now, after it looking like it's not going to work to get out of this subpoena, they go and hire another attorney, it looks like they realize they are going to have to comply, and that there might be some merit to Nicepool being Justin. And if that's the case, it could really change the trajectory of this lawsuit. So I guess for now, we'll just have to wait and see. Till then, this is Cassidy O'Connell saying stay well and stay tuned.